Hi again, Attorney Steve Vondran here with you. We are talking in this video about BSA software audits and software settlements. Okay, this is a big deal. As we've been talking about, is the BSA is made up of a bunch of different big software companies: Microsoft, Apple, Symantec, Adobe, all these big companies, right? And so what you may get as a small business owner, what we see is basically small businesses being targeted for these types of audits, sometimes based upon an ex-employee who has left, or a disgruntled employee who has left and informed the BSA through its website that you may be pirating software, using software without paying for it or without the proper number of licenses. So, these are cases where you then get the letter, and a law firm, usually an intellectual property law firm, is demanding that you audit your internal systems and basically provide them a full detailed accounting of all your software that you have, that you're using from their member companies on your different laptops, servers, so forth, and give them an accounting of everything you have and show your proof of purchases, your receipts, to show them proof that you're actually paying for the software you're using. So lots of times these will be based on informant tips that you're violating the law, that you're using softwares without a license, basically infringing under federal copyright law. So these are the kinds of things that we see at our office. I wanted to go over real quick a settlement agreement. This is a settlement agreement that we got from one of the law firms in a case that we're handling. But basically it talks about, it goes through, we've received your audit materials, thank you, this, that, and the other. We're going to hold off for litigation right now. Looks like we can get this handled. And it talks about under the Copyright Act, damages per each work infringed. So in other words, every time they find some type of infringement, can reach $150,000 if willfulness is shown. In other words, willful copyright infringement. We've done another blog on copyright infringement. Just Google Vondran copyright infringement, and I think you'll probably find that, willful copyright infringement. We have a blog on that. It says, under the Copyright Act, damages per work infringed can reach $150,000 if willfulness is shown, and according to having some unlicensed software on our computers, the exposure could exceed $900,000. That's $900,000. So you need to just bear this in mind as to the kind of exposure that you're going to be pushed with. And they say, even if there's not willful exposure shown, we think we can recover $150,000 or whatnot. Also going through this agreement, one thing that you'll see is the law firm also, in addition to these exorbitant fees that are looking for their own attorney fees, $7,500 for their own attorney fees, $5,000 for their attorney fees, and willing to settle your case, for a fraction of your $900,000 exposure, $30,000, $40,000, $20,000. So, these are the kinds of responses that you can get in these types of legal demand letters. Now, also, so you add that up, your settlement fee plus your attorney fee, it starts getting up there. That's why we try to tell clients these are very serious matters. The way these companies look at the BSA, the way they look at their software is, that it's an expensive product. This is what they make, and that you should be paying not only the fee, the manufacturer suggested retail, which they're happy to give you, the manufacturer suggested retail price, which is usually inflated, with a multiplier of 3. So, you for example, you have a missing Microsoft Word at $139, multiply it times 3, and next thing you know, they want $500 for that. So, like I said, these are very serious matters when you're charged with federal copyright infringement in your business, particularly in small businesses, which is what we have seen, targeted, if you will. And again, they will claim that it's based on reliable informant evidence, so they don't consider this to be some sort of act of targeting the small business owner. So just let me give that caveat in here. I'm not saying that per se that's what's going on, but that's what we've seen. So anyway, that's a thing. One other final thing that I just wanted to point out is you see this type of language in these agreements as well, which is, you will permit the BSA to conduct 2 inspections per year for 3 years, 2 years, whatever the case may be. These are something they try to do, is have the right to come back and do subsequent audits of your internal systems to see if you're compliant. If you're compliant, then they'll pay the costs of the subsequent investigation. If you're not compliant, then they'll try to hit you with, likely another copyright infringement claim. So these are the things that are at issue in your letters. These are the things we try to negotiate on your behalf. Obviously, we try to get this liability down to a manageable piece, and that's basically what our service does for you. Now, if you end up in federal copyright litigation, of course, we can represent you, asserting all your claims and defenses that may exist in your case. Especially challenging the willful prong of this, which it's not the easiest standard to prove willfulness. So that's a basic overview. If you need some help in your BSA software audits, you get a software licensing letter demanding that you submit to an audit. Before you throw away the letter and say, well, I'm just not going to respond, I'll let them sue me, just be aware of what they might be trying to sue you for. Okay, so it's not exactly a cakewalk in the park. So there is some potential exposure. So if you have more questions, find us out on the web at askattorneysteve.com. That's askattorneysteve.com, or give us a call to discuss your case in confidence, 877-276-5084. That's 877-276-5084. Thank you. Have a great day.